What's going on, everybody? This is Lady Luck. All right, we got to do it. I got some content lined up for you guys. I'm going to do at least 3 videos today. It's MLK weekend. Kids out of school tomorrow, and we bless God for it. So what we have up first, I'm going to do 2 videos on Super Stupid because it needs to be done. First video I'm going to do is this live stream that Jedediah did last week, where he was able to catch a court hearing with Super Stupid and her weird attorney that I'm still wondering how he's being paid. Who's paying Max Solomon's attorney fees? And in what capacity is he representing her? Is this in her official capacity, to which, thank God, she's going to be voted out of soon, or her personal capacity? And if it's in her personal capacity, he definitely should not be billing the village of Dalton or Thornton Township for his billable hours. He should be getting that out of her personal paycheck. But that's, they had a hearing, and I think he who will not be named in the Lady Luck Club was added to that particular complaint. And what happened was they had a hearing, and the opposing counsel, from what I've gathered so far, basically filed a motion on Court Rule 138. So you're going to hear that a little bit throughout the hearing here. Jedediah just got some new equipment. I'm very proud, very happy for him. And he is able to, at some point midway through this, you'll hear the sound become more clear with the court hearing, because he was able to merge it into the live stream. But right now it's coming through his phone, and the judge chews them out. And when I say them, I mean Super Stupid and Max Solomon. He has to be one of the most incompetent attorneys that I have just ever heard. And I did not have to go to law school to say that. He is god awful. He has filed so many frivolous lawsuits and complaints. It's going to get to the point where the courts are going to just be like, we're tired of you, dude. We're tired of you too. We're tired of you. You know better. You went to law school. You're supposed to be an upstanding member of the Illinois State Bar. You're an officer of the court, and you're filing these frivolous complaints. And if you're not filing them to the wrong court, the improper venue, you're just filing the wrong documents, or they're not sound legal. There's no legal premise to it. Didn't cite one case law, nothing. You can't claim everything's illegal because you don't like it, but you can't cite the law, the state statute, the municipal code, whatever it is, that's actually been violated. And that's what you're gonna, if you read some of his filings, it becomes that pattern. It's more of just his client's complaints and her nonsense spilling out into court documents and somehow landing in the court of law. And these judges are going to get sick of it, Max Solomon. And I hope to God this judge still decides to sanction your ass, because it is a vile waste of tax dollars and the court's time when they could be hearing legitimate cases. So we're going to check this out. I don't know if I try to cover material that most people don't cover, because that's what makes me Lady Luck. And things that people need to hear and give commentary on it that people need to know. No, I'm not an attorney. I didn't go to law school. You will not catch me dead on a law school campus. But I do take an interest in it, because the law does affect our everyday life. And then you can understand, when I say this is a frivolous lawsuit and it's going to get dismissed or denied or however, you can understand why, and have some sort of base knowledge in this, and understand how this is impacting, the residents in Dalton and in Thornton Township. So let's get to it.
Don't say nothing. Let me listen. Don't nobody come in there and say anything. I'm just trying to get this court. Let me hear it.
From the Attorney General of the of the state of Illinois. From counsel, it said you gotta have a place that's large enough to allow everybody in, especially, I might add, parenthetically for myself, when there's such a controversy in the village of Dalton everybody should get to know everything that's going on, maybe be heard if it's open up for questions, but certainly see their government at work or not, as the case may be.
So far, the judge has said, based on and I'm assuming he's citing case law or an op-ed of some sort from the Attorney General in the state of Illinois, that you need a large venue to accommodate, people who want to come out and basically see their government at work. So if it's a town hall meeting, a caucus vote, whatever, you need a venue that is large enough to accommodate a lot of people, because they all have the right to go in and observe and see what their government is doing for them. So when you're an elected official, you are there at the will of the people. You were put in that role as the super mayor, supervisor, whatever you want to call yourself day by day, super stupid. Because somebody voted you in. Now, there are many dirty things that were done, but it was not through some appointment from a governor. It was through an electoral process. But people have the right to be able to assemble, to go to a venue that's large enough to accommodate the residents and the voters, and to participate in a town hall meeting or to participate in a caucus vote, to see their government at work and see what the hell is going on and see what they're doing. So far, that's pretty much what he said, and it's going to be a little hard to hear until it's going to just get some clarity once the call is merged in with the actual live stream itself. But
that's the reason they opened it, according to them.
And it's a valid argument. They said we need something large to accommodate all these residents.
Which you did in this case too. Let me ask you another question, since this is injunctive relief you asked for. Every complaint for injunctive relief has to be verified and sworn to. And you say that in your complaint that this is verified and sworn to. You say it's a verified complaint. But
sworn to being you have an affidavit or you have a verification that's been notarized, where it basically says that the statements made in this document are I swear and attest under the penalty of perjury to be true and genuine to the best of my ability or the best of my knowledge. So he submitted a complaint that was missing either the affidavit or the verification that goes along with that complaint, where it basically has that same language and it's notarized. The affidavit will be notarized too. Has to be notarized and signed. And you're basically saying, I swear and attest that these statements are true. It's almost similar to the oath you would take if you were deposed or cross-examined or anything like that in a stand, in a hearing. You take the witness stand, you swear and attest that the statements you're about to make are true to the best of your knowledge. Swear to God, put your hand on the Bible. That's pretty much similar to what he's saying, except it goes along with your complaint. When you're asking for some sort of relief from the court. And that was missing in this complaint, which I keep saying makes it even the more frivolous and bogus that you didn't even have the most crucial component of this complaint completed. And he's a bar licensed attorney. Dear God. Dear God.
Verification in this complaint. That's right. The body of the complaint that you saw.
Exactly.
That you saw
Justice.
as an officer of this court claimed it was a verified complaint. But you agree it wasn't verified. Yes or no? And
yes, he's agreed.
That an injunctive relief request has to be subject to, at bottom, a verified complaint? For injunctive relief when it wasn't verified. Correct?
Correct.
Yes or no?
Yes. That's what he did.
I didn't rule anything about 137 yet. That's why we're here.
Right. Get him, Judge.
Rule 137 does say that if
Get him.
he was brought to the attention
the lawyer or the parties may wrongfully denied. That was remedy within Rules 137. And within
Y'all hear some noises in the background. It's my children. Just FYI, just pointing that out because I'm a mama.
Well, you didn't drop everybody. It was still an unverified complaint that served as a basis for a request for injunctive relief, which by black letter law is against the law.
Right. Because it is. Yep.
Yes or no?
Yes.
What about
The judge is asking very simple questions. Yes or no. He's an attorney who allegedly went to law school and graduated and passed the bar. Answer the damn questions, counselor. It's that simple. Yes or no. See, here's the thing. You can't go to court pretending like you're still doing a live stream video for Facebook. That's not how it works. Y'all, court is supposed to be boring. With the reaction videos to something that's supposed to be very, very boring for most of us. I don't understand why he thought that this somehow the judge will not get in his ass about this nonsense and buffoonery that he is allowing his client to keep stirring up. And it makes Max Solomon look even more incompetent. You're her attorney. It's your job to tell her the law and say what you will or will not do when it comes to filing these complaints to the court. Stop doing it because she's calling you saying, this is what I want. Well, you're not going to get it. Find something else to do. Go read a book, girl. Get the hell out of here. You're an officer of the court. You have the right to say, I'm not taking that case to the court. That's no validity in that. I'm not going to go to the court and you're not going to have me look bad because judges talk too. Them judges, they get used to seeing some of these attorneys, depending on what type of specialty of the law you practicing in. Let's say you're a family court attorney. You're going to be in family court a lot and might come across the same judges. So you build up a rapport with the court and with these judges. And they talk. They know who their problematic attorneys are and counselors are. The ones that are usually on top of their A game and the ones that don't know how to somehow submit a verified complaint seeking injunctive relief. That sounds rudimentary to me. Like almost just kind of the premise to most complaints that you're asking every complaint when you're asking the court. Just like the judge said, according to the law, when you're seeking injunctive relief, you know it has to be verified. That's basic. That's very simple. Why the hell is he not doing that? And it's not the only one. Nope, not the only complaint he has filed to the court that was not verified. It is not the only one. That's the sad part about it. Jesus Christ. He should be sanctioned.
Mr. Solomon.
That use that a body, the first, actually was the first law.
Verified. That wasn't, that you said it was verified when it wasn't.
Right, so you lied about it.
It's a matter of law for you to request injunctive relief, correct?
Right. That's why we did it, Your Honor. Your Honor.
You amended it.
Language was a typo.
Doesn't matter.
Its topic or the heading did not include verified.
Anything else, Mr. Solomon, you want to tell me?
That judge is sick of that. Anything else? Why it shouldn't be
This
given.
week only, all Domino's menu.
As to why
Yeah, I had a commercial in there. Y'all be all right.
sanctions shouldn't be given.
Why it shouldn't be given.
Why this matter, Your Honor?
So basically, the opposing counsel representing the Thornton Park District filed a motion for relief to be granted based on Court Rule 137. And that speaks specifically to sanctions. So what he's saying is, tell me why I should not grant them their relief they're seeking regarding a sanction. I want to hear from you. I'm going to give you the chance to tell me why it should not be given. They were also seeking attorney's fees and court fees and stuff like that for having to defend the very dumb, frivolous lawsuit that they filed against Napoleon Harris and against the Thornton Park District or whatnot for that caucus vote. They went and had a meeting in a caucus vote without me. Yeah, because they don't have to have you. This is not something that has to involve you, little girl. But the judge is basically saying, you guys filed this unverified, frivolous nonsense. And now, here's where the bill comes due. Tell me why I should not grant them the attorney's fees, court expenses, and that sanction they're asking me to give against you to keep you from filing all these frivolous ass complaints to this court. It's exhausting. They're tired of having to defend every little thing because your client is a piece of crap that does not belong on this planet. God, get off of our planet. Leave Earth.
When you say someone has festered and encouraged continued division between constitutional officers, are you telling me you didn't intend to say what you said?
He meant that.
Focus was driven by the result of the actions.
And when you tell me that you filed an injunctive relief count and a declaratory action count, when you know it has to have as its basis a verified complaint, and you knew it wasn't verified,
very basic.
that was intentional too, wasn't it?
Yes, it was.
Just a mistake.
That was not intentional. That was
No. He's lying, Judge. There are other complaints that he has filed that were not verified. They have to be e-filed. I know you guys have some sort of e-file, e-serve system up there in Illinois. Because we got it here in Georgia. It's called e-file GA. Like e-Tyler or something like that. But at the end of the day, that's not the only complaint Max Solomon has filed that was improper, sent to the wrong court, definitely unverified, without an affidavit or a verification statement notarized or anything, nor was it based on any law. So trust me, Judge, it's not the only one. There are others. He's just doing whatever Super Stupid tells him to do, and he's not telling her, here's where I draw the line. You're not gonna have a whole court mad at me on this nonsense you bringing up and you demanding. Why would he even phrase it that way? That's what the judge is trying to get at. You're talking about festering. Why would you even put that term in this damn complaint? And you're a whole ass attorney. Get out of here. Out of here, bro. Get out of here, bro. Yeah.
That's number one. The meeting happened at night. The next morning we were in court. And I knew at the time that filing a complaint is subject to amendment, is subject to 137.
How are they subject to amendment?
What's the attention that it wasn't verified?
It's subject to 137 as soon as you file it, isn't it?
Yes.
There's no exception because of emergencies. No. Is there?
No, it's not. So the complaint that they filed against Napoleon Harris, remember that lawsuit they filed where they had that other mayor from Dixmoor on it, Fitzgerald Roberts? That was first filed as an emergency motion for relief. Regardless of whether it's an emergency or just a standard motion for relief, at the end of the day, it's still subject to Court Rule 137 that speaks of sanctions with regards to filing frivolous nonsense that are especially unverified, have no basis in law at all. And if you don't even get granted the motion, then it really solidifies the frivolity of that actual complaint in and of itself. Not only did you file this unverified to the wrong court or just, based on some nonsense because your client feels a certain way that no one gives a damn about, but you don't have any finding of law here. Well, where are the facts on this? What are the evidence? Cite one case law. Do us all a favor, Max Solomon. Put one case law in your filing. Let's see how far this goes. Like that, it's not even on a finding of the law itself. It's just garbage. That's why I keep saying they're frivolous. And a lot of times, if you just look up and read what a typical or standard verified, properly filed complaint looks like, there are certain components based on court rules and the law itself on how these pleadings should be structured and how they should be filed and submitted. And if you understand the premise of that, at the very least. Even if you don't understand it fully, but you at least know some of these pleadings have to be written and structured a certain way. You can't just send in whatever the hell you want, however you want to do it. No, the court is going to reject it because it's not properly filed. You didn't follow the courtroom procedure on how to do this. I had to learn it the hard way. I'm also not an attorney. He is. That's what makes this so horrible. He's a damn attorney. You're supposed to know better, bro. And when you know better, you do better. The more you know. The incompetence is staggering. It's subject to Rule 137 when you file it.
The attention of the parties, and they decide to right away. And besides that, Your Honor, letters were present before you the next day. I mean,
I'm not worried about that.
No one is.
What you did, how you did
you bringing up somebody else.
Based on existing law or not. Existing law as to the right of the Park District to do what it's doing per statute. Existing law as to how you file a complaint.
Right.
Existing law as to stating it's verified when it's not. Existing law as to
right.
having a basis for the request for injunctive relief.
Right.
Based on a cause of action.
Yep.
And based upon a verified complaint or not. At the time of filing.
At the time of filing.
I don't look forward and I don't look before. I just look at the time of filing. That's the law, right?
That's what the law says.
There's no argument about the facts.
That's why injunctive relief is what we ask for based on the facts that we allege.
Based on the fact that the Park District opened up its door to someone Mayor Henyard doesn't like.
Right.
That's
it.
A fact, right? And you think that's okay to sue someone because they did something that they were constitutionally authorized to do and statutorily authorized to do because your client didn't like it, right?
That's exactly what happened. Can we bless God for this judge? Watch out. Lord, we thank you. Shoot that boy out. And keep at it, Judge. The world is watching and we're all clapping you on for chewing out Max Solomon and his dumbass client. Him, whatever. It's so epic. I would have loved to have been in that courtroom to see that come out of that judge. And then to see the look on Super Stupid's face as her attorney gets chewed out about why the court does not give a damn about your feelings. Yowza. I would love to be there to see that. Epic. You would think more judges would say this. Don't be afraid to say that. Like, listen, go there. When it comes to this, I understand these attorneys, we're fellow officers of the court. Get past that point, please. And just tell the truth. No, your client wanted you to file some dumb crap to this court that was unverified with no finding of the law at all. Frivolous in nature. All because something happened she didn't like, and that's it. Like we supposed to care about that. I love it. I love it.
Okay.
Yes.
That's what you did, right?
That's what you did, though.
This is not about the mayor.
It is. It's all about her. She's a narcissist.
Yeah, 4-2, 4-3, whatever.
This is about suing the wrong person, Mr. Solomon. You didn't voluntarily dismiss this, did you?
No, he didn't.
Did you or not?
No.
So
So that means you meant it.
Is it my job to act as your lawyer?
Nope.
To bring something to your attention?
Nope. Woo! Chew him out, Judge.
We're not talking about the other party who you added as a plaintiff without his consent.
Yes.
Dropped him. That's just part of the rest.
Yeah, that happened. That happened with the emergency motion, like I said earlier, where they named one of the petitioners as the mayor of Dixmoor, Fitzgerald Roberts. And The next day, that mayor was like, oh, hell no. And they had to take his name off of the complaint because the mayor basically said, listen, y'all added me to this BS. I didn't ask to be on this. I don't know where she got it from that I wanted to be a part of this ridiculous lawsuit. And you're not going to drag me and Dixmoor, our tax dollars, my good name, or my attorney through this stupid case because this heifer is mad and she wants other mayors to join her in this frivolous fight that she has already lost. Girl, you weren't nominated. You're not eligible to be a write-in candidate per state statute because you lost the caucus vote. So she's trying to get the court to basically order a whole new caucus. And her incompetent ass attorney can't even file a document or a complaint and a pleading correctly. And the judge is like, you want me to sit here and grant relief based on some nonsense because the mayor didn't like it. Who? While they over here doing what is considered constitutionally protected activity. All because she don't like it. Everybody's supposed to be disenfranchised because of her dumb ass. That's not how it works here in the United States of America, you Ewok. Get off our planet, girl.
Just of the filing of this complaint. Understand. I'm not even including that.
Nah.
As to what you
He ain't
did.
got that
And
yet.
that's Andrew Holmes. They added him, and he didn't want to be there. Andrew Holmes tried to leave. The judge didn't let him.
Go ahead.
Andrew Holmes said he never told them to put him on this complaint allegedly. That's what I think they're saying.
But it has. There's legal time, money,
I have to look at that again. I would like to see the filing on that because I think the judge was referring to the emergency complaint for the injunctive relief that was not verified, where they added that the mayor of Dixmoor, because otherwise, what would he who would not be named benefit from this particular lawsuit in general being added to it? So I need to look at the filing. Maybe. I know that happened with the mayor from Dixmoor. That certainly happened. And the judge any judge would take issue with that. You adding people on a lawsuit that didn't agree to this. They don't have anything in writing saying they're willing to go, support by being added to this complaint. That mayor probably was selling super stupid. Like, I understand how you feel. I feel you on that. But the caucus was a legal electoral process, and you're not gonna stifle a legal electoral process that robs the people of their voice. They had the right to do a caucus. They had the right to assemble. They had the right to meet up at this venue or whatever at the park district. They had the right to do all of that. Constitutionally protected activity. This heifer is suing people because someone followed the U.S. Constitution. Get out of our country, girl. Get out of here. Get your bum ass out of here. But I have to see the pleading to see if it was about he who will not be named. I'm not saying that man's name.
Including trustees, anybody that comes to partnership. And my concern here is that for them to say in a government agreement, it's wrong because the partnership opened its doors when the mayor got elected and she had celebration. The partnership, the non-kind of celebration was she was one of the call. And then I would like to end by making the point that there is no law that was known and that the full support and the board was ready to be about this because they felt they have a fiduciary duty to come into this court and demand to be reimbursed for all their legal fees that they should not have been paid. They could have used for other things in that partnership. And in addition to that, I'd like to add one more thing. The park has charged the village with the fee, which they do charge for meetings, but they have to work with them for situations in the community.
What about
Okay, so the opposing counsel, from what I picked up, was saying basically, she has locked out assessors from, the building. She has tried to hinder people from assembling in the past to have meetings. The reason why they met here at the Park District is because they were being locked out of the town hall. Like, she does the most heady ass nonsense that would violate many, many municipal codes and robs people of being able to exercise constitutionally protected activity. When your tantrum, your stupid temper tantrum, starts to infringe upon the constitutional rights of others, I have a big problem with that, and so does the judge. So does any other judge that is neutral, impartial, and objective. Every judge would have an issue with you infringing upon others' constitutional rights and the right to exercise protected activity that they have every right to do. That's not illegal. And all because you don't like it, now you want to sue them for it. That is the epitome of infringement upon someone else's rights. The epitome of that. Because you're throwing down, I don't want to say a slap suit, but you're throwing down these frivolous lawsuits by saying, because you did this and I don't like it, I'm going to sue you for it. And then you're trying to manipulate and abuse the courts to scare someone into not exercising constitutionally protected activity. Their rights to assemble, right to protest, right to vote, right to have a caucus, rights to have their voices heard, to see how government works, to see what their government is doing for them. All of the rights that these people have as citizens, as tax-paying voters. And all you're trying to do, Super Stupid, is infringe upon that. Of course the court is going to take issue to that. And if Max Solomon wants to be stupid enough to file a frivolous filing or complaint, egging on this nonsensical behavior, giving you a pass to throw a tantrum and infringe upon the rights of others, his ass should be sanctioned then. He should be sanctioned for having the audacity to file that damn complaint. Sanction the hell out of him.
Failure of the Park District.
Come on now.
Attach, what its reasonable fees and costs were to this Rule 137 motion. Isn't Mr. Solomon entitled to know, refute, talk about, examine? And I am too.
At what point does a salad become a...
That's not true. It's not only if it's granted. There's nothing in the law that says that you can dictate what the procedure is. The law says you should have attached your reasonable fees and costs to your motion so that Mr. Solomon would have an opportunity to review them, refute them, argue that they're not reasonable, etc. And I could look at them too. Are you telling me that you think that this should be bifurcated? I'm asking you a question. I'd like an answer.
He asking both of these counselors questions, and we want many, many answers. So basically, from what she said is, listen, all the things that she had, Super Stupid has been doing and adding on filing these frivolous lawsuits, I've had to come to court and defend these nonsensical complaints that are unverified. There are court costs and fees and attorney's fees, and also I'm asking for you to sanction this idiot for filing this stuff, because it's a waste of time. There's other things that could be happening in the world. I mean, anything else could be happening right now. But she did not attach the reasonable costs and fees for her attorney's fees, her billable hours, any court fees that they have, maybe filing certain documents, subpoenas, stuff like that, and associated costs with anything related to submitting documents to the court, anything related along those lines. Even for like travel, per diem, those types of things that she had to pay just to represent her client in this matter. You need send the invoices here. I think that's the biggest problem that is going on between Thornton and the Village of Dalton. A lack of financial disclosure. So the last thing you want to do as an attorney is have a judge tell you, why didn't you attach your attorney's fees if you're asking me to grant you attorney's fees? I need the exhibit. I need to see what that is. So she gives a reasoning as to why she didn't do it up front, which is reasonable. He's saying the law states that you need to attach it so I can review it. And yes, it's almost considered like discovery for the opposing party, for Max Solomon to have to look at as well and be able to give some sort of objection or rebuttal to say, I don't see how this is reasonable or fair, blah, blah, blah. Most times the opposing counsel will look at it and see like if the attorney's asking for attorney's fees. Attorneys typically charging, depending on the type of case, $3,400 an hour. And then, an appearance fee for court. If you're in person, most attorneys charge something around that amount. So if she submits the exhibits and that's the breakdown, he's not going to really object to that because more than likely he's probably charging the same amount. He probably has an appearance fee as well to go to court in person. That might include travel and gas and mileage or whatever per diem or some costs associated with having to represent, and defend this case, defend your client in this case. So most times the attorneys aren't going to really, unless it's just an astronomical number, they're not going to really object and go back and forth on that, because then the question would be, well, hell, how much are you charging? Just because you don't charge what I charge, you might not be doing half the work I'm doing. You might not be that credible. Maybe I earned it and you didn't. I mean, that back and forth argument can be done all day. So most times attorneys are not going to really bicker and go back and forth over an itemized expense of attorneys and court fees like that. So they'll probably agree, like if it ends up being where the judge grants that relief, then this is what you'll be, ordered to pay. And, they don't go back and forth on stuff like that, because it brings up the question of how is Max Solomon's attorney's fees being paid and how much does he charge? We're all still curious to know that. Who the hell is paying Max Solomon? And in what capacity is he representing Super Stupid? So he's not going to want to answer those questions. That could be easily challenged in court. So more than likely, he's not going to go out his way to challenge it if he's smart. He hasn't been, proven to be that so far, but whatever. If he's smart, he won't challenge it.
Bifurcating court. And the reason it's usually bifurcated because one of the expenses me and the only reason everybody fucked up. As well as the amount motion, as well as the attorney cost, as well as the certificate. So the reason it was not included was done to pay in the sense that the fees are still ongoing.
Thank y'all for this equipment. Thank you.
No of this fee. That's the only reason it was not.
I'm so happy he happy.
It would have been better for you to start the process by attaching the fees engendered already, attorney's fees.
So if you didn't really catch that, because it took me a few good listens to catch and understand half of what she was saying. She's basically saying, listen, bifurcating means you separating the costs or whatnot. And, she's saying, listen, I recognize that I should have attached it up front with the motion. But one reason why I didn't judge is because this is one of many dumb court appearances and hearings for stupid, frivolous lawsuits that have been filed from Max Solomon on behalf of his dumbass client. And I'm adding words to this. She didn't say that, but this is my spin on it. And it's my video and my channel, and I choose to spin it. So his dumbass client threw a tantrum, wanted him to file his stupid complaint that was unverified and frivolous. This isn't the only one. So I got to keep coming to court or having Zoom hearings and having to draft responses and objections and motions and stuff to defend my client, and it's all this buffoonery that he started with his client. And if I bring an expense list of the fees that I'm asking this court to grant me, I don't want that to be the message that this is all that I'm asking for, because it's not. This might not be the only court appearance we would have to have for this particular matter. And guess what, people? It's not. They have another court date coming up to continue the hearing on the actual fees itself, because he's going to give her time to submit the exhibits to determine, what her fees are. He basically grants her the request and saying, yes, you are entitled to attorney's fees and court costs and stuff like that. And what he does, eventually end up doing is saying, okay, I'll give a continuance on and we'll have another hearing where you'll have time to submit those exhibits and those expenses, and then give the opposing party time to look at it. He can come to court and complain about it all day, but unless he wants to be questioned on his attorney's fees, he might want to shut the hell up. And then I'll grant the judgment on the exact amount. And she's saying, I didn't do that right away because look what happened. We have another hearing coming up, and I don't want him to get in here and say, well, Your Honor, the opposing counsel only asked for, $5,000. All of a sudden now she wants an additional $2,500. That will, I'm just throwing out numbers just to kind of prove the point. But, why is she asking for more? That's not what she put in the motion. That's not what we came to court last weekend and talked about. That's not what we discussed. So she doesn't want to be gridlocked to only being granted a judgment of a certain amount, knowing that, let's say if she would have presented that exhibit for this particular hearing, then you go back in a month and then what? Because then that's another court appearance fee, whether it be in person or on Zoom. It's still billable hours from that attorney representing the Park District. She's going to want to get paid for that. So she's going to want that to be included. And she doesn't want the judge to say, well, I'm not going to add on and grant something that you're just not submitting to me today. Well, Your Honor, this is the second appearance. I didn't know we was going to have a continuance on this. I didn't expect to have to defend my client on this nonsense, but whatever, we're here. But it's not fair to not be paid for all these appearances and all the work that I'm putting into this case. All because Max Solomon has the dumbest client on earth that we're all still wondering how he's being paid. So I'm not going to limit myself to just saying, all right, just give me the $5,000 that I'm asking for so far, when the judge turns around and gives a continuance and schedules another hearing, which means that's more attorney's fees. And she doesn't want Max Solomon to say, well, she didn't ask for that in the exhibit. Yeah, no, duh. Because we hadn't had a second hearing on this yet. So, having it bifurcated would be the easiest way, the easiest response to give the judge, especially when he's kind of like chewing everybody out at this point. He's just going down the line. He ain't sparing nobody. But he's citing the law. He's saying, by law, this is what you were supposed to do. I understand if there was an exception to this. And it's a reasonable argument. But you got to present something. So I'm going to give you time to do that. And that's what it comes down to. But that's what she was trying to say. I don't want to be gridlocked to just presenting a number today. And then who knows how many more hearings we're going to have on this same dumb matter that he filed that's still frivolous, no matter how you put it. So, no, she wants to be able to get paid for all of her court appearances on this. And who can blame her? Seriously. Can't blame her.
Thank you for that, and I will always in the future make sure I do that. But I would like to add that
See?
I have a
reasonable response.
And I did read the statute, and it wasn't something that had to be in there, and the fees are still incurred, and that's the only reason I didn't do it, because it would have gave him a false impression.
All participants are unmuted. The conference has been unlocked.
See, that's what she's saying. It would have given him a false perception to think that this is all I'm asking for, basically, to sum it all up. And I don't want him to falsely presume that this is all of the fees that I'm asking this court to grant me, and this all he has to pay. No, hell no. You gonna keep paying for this BS. You brought this nonsense upon all of us. You're gonna pay the price for it. And the judge is more than willing to agree to that. So, like I said, it's a fair legal argument. And my comment was basically saying, yes, that's the law, that she should have attached it, and it's not initially bifurcated. You got to request for it to be bifurcated. But understanding her position and her point she's making, I mean, hell, how many more hearings are we going to have on this stupid issue? Yeah, I want to get paid for every single one of them. So I'm not going to just give a number and then he thinks that's it. Nope. So, yeah, understandable.
Ironically, I think there's more at the end than was at the beginning. And so,
yep. This is not ending at all.
She didn't need for the fee, but those are the fees.
Right.
Okay.
She didn't send over for those fees. There you go.
Filing of frivolous and false lawsuits. Tolan versus Davis, 295 LF 3rd, 652, specifically at page 657. Also, Addis versus Exelon Generation, 378 LF 3rd, 781, at page 796 of 1st District, 2007. The rules designed...
Max Solomon, I hope you watch this. This is how you cite case law, you dumb goon. What you just saw was two case law cited. It helps to establish precedents. You know that. You went to law school. Why are your complaints devoid of case law? I mean, completely missing. And the judge is basically giving case law to support the justification of the decision that he's going to make on some of the issues that they discussed today in the hearing, with the exception of the attorney's fees, because he doesn't have the exhibits from that. He doesn't have the expenses from the opposing counsel. And actually, I think the attorney representing the Park District is the moving party in that particular motion. So the motion on the Court Rule 137 came from the attorney representing the Park District, not from Max Solomon. So in that particular motion, the moving party is the one that files the motion, the movant. And then, of course, him being the defendant and having to defend that him and his client in that particular motion. That's why he was asked, the judge asked him, is there a reason you can give me as to why it should not be granted? It granted to the opposing the other party, the moving party in this particular motion, that being the attorney representing Thornton Park District. I don't, whatever they termed it as. Like I said, I have to see the filing on this. I haven't read the pleading, so. But I just know that she's the movant in this particular motion because she's sick of this crap, and this court rule is put in place, and it's designed to thwart frivolous lawsuits, frivolous filings, especially when it's repeated behavior. It's not something he made a mistake once. You can't make the same mistake 4 times. I'm sorry. No. At some point, it just becomes a matter of you being incompetent and you need to be sanctioned. So, that's where we at in life.
Participants are muted, and they can unmute themselves.
By plaintiffs who make vexatious and harassing claims based upon unsupported allegations of fact or
vexatious
law.
Yep.
Sinise versus Climate Temp Inc. 289.
Case law
570 at page 581, a 1997 case. Rule 137 holds in relevant part that by filing and signing the pleading, both the party and its attorneys certifies that after reasonable inquiry, the allegations of that document are well grounded in fact and
the law
warranted by existing law.
There you go.
And are not being interposed for any improper purpose, such as to harass or needlessly increase the cost of litigation.
Right.
Trial courts, however, should not impose sanctions on a party for failing to conduct an investigation of facts and law before filing if he nevertheless presents objectively reasonable arguments for his position, regardless of whether those arguments are unpersuasive or incorrect. Barrett versus Fonero, 343, LF 3rd, 1184. Also Peterson versus Rondava.
So he's saying here, there's, case law to say, okay, when you're thinking about imposing a sanction, you can't impose a sanction simply because somebody filed a complaint that was based on law, regardless of whether the law itself is incorrect or misinterpreted or objectionable or anything. I mean, if it's the simple fact that the complaint was filed, the court is going to grant some level of mercy and opportunity for you to bring forth legal argument to argue the motion before the court and give you some sort of a good, assume that you're doing this in good faith. When you start filing petitions and complaints in bad faith, or you're acting, with ill intent, you're just doing this for some sort of vicious ill-intended reason, or for some purpose, whether it's to stall or prolong something or whatever it's for. But you're not filing the motions in good faith. You're filing these motions to try to sit here and to infringe upon others' constitutional rights to assemble or to protest or to have a caucus vote. You're not doing this in good faith. So because you continuously file these stupid ass lawsuits, we're going to start penalizing you and hitting you in the pockets where it hurts the most. But the court should not impose the sanction simply because someone filed a complaint that they could argue was filed in good faith and is at least based on the law, even if the law is not properly interpreted or improper or incorrect. So this is kind of just the premise to where he's going with this. It ends up being a matter where he's like, all right, I'm not going to just impose a sanction because you filed it, seeing that you're saying to me as an officer of the court that it was a mistake that you filed an unverified complaint, even if you amended it, and that you're alleging you filed this complaint, you tried to act in good faith. But he should have been sanctioned either way, because it was ridiculous. It was ridiculous. I don't care what you're saying. He filed this listening to his stupid ass client,
Justice Broussard.
She gonna get him jacked up. He obviously doesn't care.
Writing, who said, quote,
Max Solomon does not care.
Whether the imposition of sanctions is appropriate, the court must determine what was reasonable for the attorney to believe at the time of filing, rather than engaging in hindsight.
Is he about to sanction Solomon?
God, that would have been epic.
Meaning 313.
He can still do it.
1 at page 7.
He can change his mind.
Ray Estate of King at 245 LF 3rd, 1088, 5th District, 1993. Case, the court said the trial court's refusal to impose sanctions in an unsuccessful will contest in that case was not an abuse of discretion, even though counsel was advised that as a matter of law, the will contest did not lay, where counsel had a legal argument to the contrary, albeit an incorrect one.
Right.
I recommend to the parties to read.
So you filed the complaint, you brought forth the legal argument. It was still incorrect, but it was a legal argument nonetheless. And we're trying to give your ass a little mercy here and assume or hope that you filed this complaint in good faith, despite the fact that a damn attorney filed an unverified complaint still. And it is considered improper because it was not properly filed based on court rules or the law. So, and court rules are going to be stemmed from the law itself. So simply because it was not filed based on the law, and it was not properly done based on what the law says, how it should be structured and filed and submitted to the court. that would be considered improper. So when I say something's improperly filed, I'm not saying he can't file it. It's improper. It wasn't done based on the standards from what's stated in the law. And believe it or not, the law has templates and examples or samples of how certain documents and pleadings should be filed to the court. So you know that if you went to law school, and he went to law school, so he has no excuse. And if he doesn't remember or understand, Google it. Look it up, Max Solomon. Google the law and look it up. Just type in sample of, motion for injunctive relief in the state of Illinois, and the state statute will come right up. That ILCS code come right up, and you can get a sample of how this pleading should be filed and submitted to the court. Look it up. I had to learn that the hard way as pro se, and I didn't go to law school at all. And I'll tell y'all something. I hate not having an attorney because of all of the administrative work that goes behind that stuff. It takes a while to, come and bring together a proper pleading that is based on the law and hopefully factually correct, as much as I understand it to be, even with advice from attorneys, pro bono advice on how to submit something. Because attorneys aren't perfect. But it's something you still want to at least put some good faith effort into doing the right way. So if I forget, I forgot the verification that wasn't notarized. They might read and be like, well, it sounds decent argument. It was still improper because it was missing the notary, or it was missing the verification, or there's no affidavit, or it wasn't served in person to the court like the court rule and state statute says it should be. It's still improperly done. So he's saying, yeah, you could file your complaint and have a legal argument. The court is not supposed to just sanction you for doing it because we didn't like it. No, it has to be to the point where it looks vexatious or malicious, or just looks like there's some sort of ill intent from a repeated, consistent pattern of behavior here. I don't see how the judge is not seeing that, because we're all watching the news. Judge, please watch the news, please.
By the way, attorney sanctions.
It's all over the news. That's all she does is get somebody to file stupid complaints.
A law review article by my friend, Judge George Timberlake.
Because judges talk. Judges talk.
In which he comments that Rule 137 was patterned after Federal Rule of Civil Procedure 11 and is aimed at reducing frivolous litigation. Quote, its purpose has always been to combat frivolous, false, or baseless actions.
Yep.
And prevent the harassment and expense that accompanies such actions.
Mm-hmm.
At page 1029, and citing Reedy versus
He even
Reedy,
giving the page numbers.
333 second, 145, and pages 161 to 162. In Chicago Title and Trust versus Anderson at 177, L at 3rd, 615, a 1st District 1988 case. The court, in reviewing Rule 137, said that a reasonable inquiry by counsel involves, quote, an objective standard based upon the circumstances existing at the time of the pleading. It at page 623. The court stated that an attorney cannot just rely on what a client tells him or wants the pleading to state.
Can you, Lord, Lord, we thank you. That's exactly what I just said earlier. You don't just file a complaint because that's what your client wants you to do. You have the authority and the ability to tell her ass no. As an officer of the court, I'm saying no, super stupid, you dumb Ewok. I'm not doing that. I'm not filing a motion on that. I'm not filing a lawsuit on that. You get sued all the time. You the one sitting here. She's so hypocritical. Y'all narcissists don't care about being hypocritical. They don't care about being contradictory. They don't care about that. Narcissists, psychopaths, sociopaths, they don't care about hypocrisy. So her being absolutely hypocritical, talking about, yeah, I get sued. She made a statement where it almost sounds like she's bragging about it, like it's street cred. Yeah, I get sued all the time. Stop it. No one will stop it. Stop telling people to stop. The hell is wrong with you? We're not going to stop doing anything. So the fact that she herself said in a whole town hall meeting on national television, I get sued all the time. She should know how irritating and aggravating it is to get the lawsuits. But yet she has no problem having a whole ass attorney file frivolous lawsuits simply because she wants it done. Max Solomon doesn't work for her. He can go get another client that would at least not make him look like a bigger incompetent idiot than he already looks like. You look like you're incompetent, Max Solomon. You look incompetent. You're doing things that an incompetent attorney, or just human being in general, would do. And the judge is properly and rightfully so chewing your ass out. Boy, would I been happy to just be in the courtroom to witness that. Many more judges needs to chew him out the same way, and at some point he's gonna get sick of it as well. He's gonna be like, "Nah, I'm tired of staking my credibility and my reputation on Super Stupid. Nothing good comes of that woman. I don't know why people won't learn that the easy way. Come on now."
Rather, the attorney should review objectively the information.
Everything she touches dies and loses its credibility.
Whether facts support a claim and whether existing law supports the claim.
Ugh.
Sanctions may be available for Rule 137. Judge Timberlake wisely cautions this court and all Illinois trial judges to exercise restraint in applying sanctions. Indeed, quote, indeed, he says, by making Rule 137 discretionary rather than mandatory, the Illinois Supreme Court seems to have had this same concern in mind. One reason, he adds, for restraint is intensely personal. Before sanctions are imposed, a judge must find a deficiency in the attorney's competence, diligence, or honesty. That's Judge Timberlake's opinion at the end there. I don't necessarily agree. I certainly don't find Mr. Solomon to be incompetent.
I object. Lady Luck Club objects. What is going on? He's absolutely incompetent. Judge, please recall the fact that he filed the complaint to the wrong court to begin with and had a party named in the complaint that did not want to be named as a party to the complaint. That Mayor Dixmoor said, if y'all don't take my name off this bullshit, you better. Kick rocks Super Stupid. Are you kidding me? I'm not going to court for this nonsense. Y'all ain't finna burn through my town's expenses and budget. Hell no. And then the attorney for the mayor of Dixmoor understands the art of not filing frivolous lawsuits and pissing off the court. Don't do that. I done had some words with a couple judges in my heyday, but let me tell you something. Chabu. I don't want to go to court if I don't have to. I'm allergic to you people. I don't want to have to go near a courthouse like that. And for Super Stupid, who obviously loves getting sued because she gets sued a lot and she brags about it, to want to file frivolous lawsuits by way of counsel, how could you see this as a good thing? And he's listening to her. He's actually sitting there, yeah, I'm going to go ahead and file that for you. Yeah, that makes sense. This sounds good to me. What the hell? All he has to do is have a 15-minute conversation with her and be like, you know what? Nah, we're not pursuing that. Nope, we're not doing that. Not doing it. If you want to do it, you do that pro se. And I will not represent you in that motion. That's what he could do. how about this? I will withdraw, and you can be pro se, and then you can file all the crap you want, and you're gonna leave me out of it. Why not just tell her that? Besides, how are you getting paid again, Max Solomon? Who the hell is paying your bill? Come on now.
Or have a lack of diligence or dishonest. But it's been observed that by Illinois courts that the purpose of sanctions is to discourage baseless actions, to prevent the filing of false lawsuits without a legal foundation, not to penalize litigants or their attorneys because they were zealous but unsuccessful.
It's on the screen.
Elledge versus Riker,
They're not letting us.
REICH, 250 LF 3rd, 1055 at page 1059.
Judge cited about 6 different cases.
And again, it's clear that according to our first district, American Access Casualty versus Alcouter at 217
7.
First, page 160775.
Or maybe 8. You got 7 or 8 good cases in here.
That our Supreme Court has consistently held that the decision to
Illinois
impose
Supreme
sanctions
Court.
per Rule 137 is committed to the discretion of the trial court. And such decision will not be disturbed absent of an abuse of discretion. According to Chief Judge Garman of the Illinois Supreme Court, when
There
she
you go.
held that
Illinois
position
Supreme
in
Court.
Lake Environmental Inc. versus Arnold at 215 Illinois, 118-110. Nothing in Rule 137 requires the court to give a written finding when it doesn't impose sanctions.
Even though the judge was gracious enough to drop about 8 or 9 different case law. he said, I'm giving plenty here. Even though we all know Super Stupid doesn't read at all. Not even Dr. Seuss. She's certainly not going to read case law. But Max Solomon should know exactly what the hell he's talking about or be able to look it up. And the judge is... It sounds like the judge is pacing himself as he's citing this because he's reading it as well. Court is very boring stuff, people. But even in the middle of a hearing, a judge, if you cite case law, they're going to be like, hold on, let me look that up. Let me write it down, look it up. They'll look it up. Because, you can't expect the judge to just have the memory of a computer. They're not going to memorize every single case law that exists out there. But if you go and you cite, you're giving a legal argument, you cite case law, they will stop and look it up and read it. Especially if they're trying to be, or give the appearance that they're trying to be neutral and fair and impartial, they're going to sit there and look it up to make sure that you're applying the law correctly to the situation at hand or to the matter at hand. So you can't just cite case law and it doesn't apply. It has to be applicable. And that's exactly what he's doing. And it's brilliant because it's showing both sides. I am not for play as the judge in this court. You all are not going to make a mockery of me or the law in my chambers, in my courtroom. And you're not going to have me looking like a fool. So here's about 7 or 8 case law I'm about to cite to support why I'm not going to impose this sanction right now. But if I wanted to, it would be at my discretion. Lord, we thank you.
Texas was waiting. And
No existing law which supported the filing of count 3. None.
None.
The statute is clear that the Dalton Park District had every right to open up its doors,
Dalton Park District. I kept saying Thornton.
every right
Sorry.
to make a decision as to whether to open up its doors for whatever reason.
Yeah, I kept saying Thornton. My bad. It was Dalton. Plus, he cited her official title as mayor. So, of course, that's mayor of Village of Dalton. But the Dalton Park District opened up their doors to have a meeting. She didn't like it. She wanted to sue him for it. for dumbass reasons, and the judge is chewing her and her dumbass attorney out, rightfully so. But yeah, I kept saying Thornton. Why I keep thinking this was about Thornton? Maybe because I thought it was connected to the lawsuit she filed against Napoleon Harris. Because that's about the caucus vote over there in Thornton. So that's the only reason why I got that confused. So sorry about that. This is with Dalton Park District, not Thornton.
To a purported village meeting. It was wrong to claim that the Dalton Park District, in exercising its exclusive function to open up its facilities to the people of the village of Dalton, festered and encouraged even more diversity. I take Mr. Solomon's argument that that was a result of what they did. But that's not illegal either. If that's the result, then that's the result.
Right.
But you and I both know, Mr. Solomon, that whether they did or whether they didn't, or whether the meeting took place in a Lexus or someplace wherever Mayor Henyard did not want it to take place, the same claim could have been made that it festered and encouraged diversity. But diversity, I wish. Division between the trustees. But correlation is not causation. The mere fact that there is division between the trustees was not caused by the Dalton Park District, who's there just for everybody in the village of Dalton.
Right. One meeting in the Dalton Park District did not create or fester any BS nonsense claim of division. It just didn't. The reason why they met at the Dalton Park District was because Super Stupid keeps locking people out, changing locks, won't let people come in, won't open up the town hall. She won't let these meetings be conducted where they should be damn conducted. So they had to find another venue. And then when they did that, now she just wants to infringe upon the right to assemble. And for elected officials to have a meeting with the citizens, with the tax-paying voters. This is how stupid she is. Now do you all see why I call her super stupid? Because you're sitting here suing someone for an action that ended up being the effect of what you caused. You locked everybody out, changed locks on doors, wouldn't open up town hall. Therefore, the effect of that is, well, we're going to have to go to the Dalton Park District and meet. And then you want to sue because they did that. So that's what he's saying, that causal effect, that's the cause and the effect of this is her locking the doors and not opening up town hall and changing the locks like she's a damn dictator. That didn't, the meeting at the Park District didn't fester and create the division. It's her divisiveness and her ignorance and her buffoonery and her pettiness and her arrogance and her narcissistic, psychopathic, sociopathic ways that is creating the division. That's what it is. And then you got the audacity to want to bring someone to court on an unverified, frivolous complaint. Oh my God.
It existed a long time before.
Get off our planet, girl.
For one reason or another.
Bum ass out of here.
I'm not pointing a finger at blaming any one party or persons as to who caused this division and why it continues and why people fail to show up at meetings on both sides, so meetings can't be held, so that the people of Dalton cannot be represented.
Y'all would like the live. They said can y'all like the live?
And your attorney general in the state of Illinois, and I recommend it to you to reread a number of times.
Like the live.
And I would like to
get
say
this up in the algorithm. That's what my vets are asking for you to do. Like the live.
For a Rule 137 violation. There's a severe
like
reprimand.
the video. I'm sorry.
And I would like to merely give you a severe reprimand. Because I know in the moment, having been a private lawyer, you're listening to the facts, you're listening to your client's energy, emotions. You represent a client, and you represent a client's
that's what I was saying earlier.
what seems to be
Keeps
their
listening to
rightful
Super Stupid
position in a case. And maybe it is, and maybe it isn't. It's not for me to decide at this moment.
No sanction, just an admonishment.
And you sometimes overact. It's like when you make opening statements to me or closing arguments. Lawyers often, having been a denizen of 26th Street, judicially,
reprimand.
As a defense counsel and as a prosecutor, lawyers often overreach.
Often.
And it's understandable.
Sometimes
And I
lie.
don't think I have ever been or have ever witnessed, well, maybe once, from Judge Earl Strayhorn, but he took it back, a sanction against someone for overreaching in what they say. But this is a complaint. This is a court document. It's guided by the rules of the Illinois Supreme Court.
Yep.
And it's my discretion as to whether a violation occurred because it wasn't written and subject to existing law. And it wasn't. And I find so that it wasn't. For the reasons enunciated in my questions and answers and arguments with you, which were done merely to flesh out the case. They weren't really arguments. The village had every right to open its doors.
Yes.
Nothing Mayor Henyard wanted or was concerned about could stop that.
Nope.
And nothing should have precipitated a lawsuit against the Dalton Park District.
Yes.
If they did so. Whether it be because of
Thank you.
the other village trustees or whether when they opened it up to honor Mayor Henyard upon her victory in the past.
So I'm glad he brought that up. He's basically saying, so your little punk behind won the mayor position. They opened it up to do a celebration ceremony, swearing or whatever there for you. And you didn't have no problem with that. Nor did anybody sue your ass over it. But you want to file a lawsuit against the Dalton trustees for going to the park district to have a meeting because you keep locking the doors, changing the locks, and refusing to open up town hall? Girl, if you don't kick rocks. There's so many words. That's what the judge is saying. And basically, to sum it up, it's just my spin on it. But that's the point he's making. What's good for the goose is good for the gander. Narcissists, they don't care about hypocrisy. Narcissists do not care about hypocrisy. She is absolutely hypocritical beyond measure. But she does not give a damn. And she doesn't care about that. The only thing she cares about is getting her way. And that's it. So he's basically saying there was nothing illegal. They had the right to do it. And the audacity of you to file a lawsuit for them doing something that's constitutionally protected activity that they had the right to do under law. And Max Solomon is not even citing law to even show how that was unlawful. Because it wasn't unlawful. It was very lawful. It was legal. They had the constitutional right to do it. They have the right to do it by law, under state statutes, municipal codes. They have the right to do it on every level. And you precipitated this BS, listening to your dumbass client, and filed this frivolous lawsuit that was unverified for what? Because she's throwing a temper tantrum that no one should give a damn about. But it certainly should not be played out in the court of law. Those judges don't care about her temper tantrum. She doesn't get to dictate and rule what goes on in the court. Her position represents 1/3 of government. Why? Because there are 3 separate but co-equal branches of power. You have the executive, the legislative, and judicial branches. Super Stupid's position represents executive. Dalton trustees represent legislative, and the courts represent the judicial. She's just 1/3 of government. And what she cannot do is exert or assert her authority on the judicial branch or the legislative branch. She doesn't get to do it. And that's what she doesn't care about. Whether she comprehends it or not at this point is irrelevant. Don't care. Don't care if you understand it or not. Super stupid. The bottom line is you don't get to do what you want to damn do. You do not get to assert your authority in that executive role over the judicial or the legislative branches. You are just 1/3. And when your ass steps out of line in that official capacity, representing that executive branch, the other two branches are supposed to pull your ass back in and reel you back in. It's called checks and balance. This is something that your goon Michael Smith claims to know and is obviously not repeating enough to you. Nor is he even showing that he has a hint of understanding of civics or how government works. That's how government works. What you're hearing this judge do is the epitome of how government works. The judicial branch is not for you to abuse and bend and manipulate to your will. They don't care about how you feel about anything. And I want this judge, if the judge has to chew out both parties to remain neutral, fair, and impartial and objective, I'm all for that. Because one thing I'm appreciating him doing is citing case law and giving background information on why he is giving the opinions and the remarks that he's giving, the ruling that he's given, or the decision that he's making. I appreciate the fact that he is citing adequate case law that is applicable. And when either attorney does something that does not follow the law, he calls them out on it. That way, you can't say that what he said to your attorney wasn't fair and legal, but when he said the same thing to the opposing counsel, yeah, she deserved that. No. What's good for the goose is good for the gander. Whether Super Stupid understands that or not at this point, I don't expect her to. But hopefully for all of you all, everyone else out there, understand, you want a judge that is at least going to be fair, get on both sides when necessary. But at least when he's getting on Max Solomon, he's coming from a point of truth and law and factual evidence that he's presenting through case law. He's not sugarcoating it. And he's being fair and impartial and neutral. He's not taking one side over the other. And he is laying it out plain and simple. So, you had your little victory lap dance in the same park district. No one sued your dumb ass over it. But you want to go sue everybody else for a meeting there because you keep locking everybody out of town hall. God, you don't kick rocks and get the hell out of our country.
They can do what they want.
Get out of the United States of America.
You have an opinion from the public access.
We got a Tiffany Henyard Super Stupid special.
It was in the public interest.
Who wants to buy her? Germany? Y'all want them?
Have perhaps a hearing on whether it was appropriate or not for it to occur there. But your argument is that they violated the law and they...
Because he claims everything illegal.
By doing it. And it was dismissed by me.
Yep. So they filed the motion saying it was illegal. Had a hearing. I don't even know if they had a hearing on it. He dismissed it. He was like, who told you it was illegal? You listening to your dumbass client tell you, a law school graduate, that it was illegal? Is that how we're doing it now? Oh, okay. So, dismiss. It was very legal. They had the right to do it. You filing this nonsense to us. See, this is why he needs to be sanctioned. He filed an unverified complaint. Then he filed a frivolous petition that was not based on any law at all. He called it illegal when it was very legal. And didn't cite law to support his dumb argument. And the judge dismissed it. That's one of many frivolous lawsuits, Judge, that this man has filed listening to Super Stupid please sanction him when you all have that hearing next month to determine how much he's going to be paying in the attorney's fees, and if it's going to be bifurcated or if it's going to be one judgment for all three people named as the defendant in the motion, that being Max Solomon, Super Stupid, and he who will not be named. So the judge has to determine whether he's going to make them pay whatever the fees and expenses are collectively or individually. And I hope the guard is individual and it is the maximum amount. If it comes up to 30 grand, make them all pay 30 grand each. Whatever it is. I don't care. Make it hurt. Make it to where they will be so discouraged from wanting to file anything else that is of a stupid nature and frivolous. and they'll think twice. Max Solomon probably will start telling her ass, no, I'm not doing it. No, ma'am. Go do that pro se. I'll get off. I'll sign off. I'll withdraw as counsel. You can go do that pro se. Leave me out of that. Hopefully, they'll still feel the sting of it. Even if he doesn't phrase it and wrap it up as a sanction, it'll be like sanctioning through attorney's fees costs. So the fees and the costs and everything with the court and what the judge orders to pay will be still hard-hitting enough to where it feels like the sting of a sanction in and of itself. And it will still deter them from Max Solomon from doing this dumb crap, listening to Super Stupid. Because, like she said, she gets sued all day. She don't care about that. She proud of that. But understand, she does not equally care about suing everybody else all day either. So the best way to get her attention, order her to pay like $20,000. See how well that go.
As a matter of fact, the facts are all
good luck to that, you moron.
But there's no basis in fact or law to argue that they violated existing law by doing that.
Right.
No.
None.
There's no basis in
no basis
fact
in law
or law for you to claim it was a verified complaint when it wasn't.
Right.
You've explained it, and I accept that, and I understand that. That's fine. But you must know the law, and you've agreed that you did, that before you can file a request for injunctive relief, account for injunctive relief, as you did, that there's got to be a verified complaint, and there wasn't.
Simple stuff. Simple, basic stuff. Yep.
I'm going to exercise my
He said it's a mark against this complaint and you. Meaning it's destroying your credibility. And I don't know why you haven't seen that yet. Why aren't you able to see that the many mistakes you keep making, whether you filing it to the improper venue, the wrong court, is unverified, it's frivolous, it's more frivolous and a lot more frivolous. At some point, you're going to have to understand all this shit's about to come on and catch up to you. And you need to stop. Now, why keep letting him keep doing all this? I don't know. But, okay. The judge was going to exercise discretion. I sure hope the guard by next month, something else happens where the judge changes his mind and exercises more discretion and actually decides to sanction Max Solomon along with order him to pay separate attorney and court fees to the opposing counsel. So hopefully there'll be a matter where whatever the maximum sanction is that the law allows the judge to order against Max Solomon, in addition to attorneys and court fees. Because let me tell you something. It is even just a severe reprimand is a blemish on Max Solomon's credibility. He's making it harder for himself to maintain his good standing status with the Illinois State Bar. Why the hell he has not been disbarred by now, I don't know. For reasons unknown, for some reason, the Illinois State Bar says, this seems about right. He's not incompetent. Oh my God, what are y'all doing? The bar should be much higher. The standard for these attorneys in Illinois should be a lot higher right now, because you got these people playing around with the taxpayers' money. And the taxpayers are getting sick of that crap. They're getting sick of it. Not just in Dalton or in Thornton, Chicago, pick another city. In the state of Illinois. And having to get these attorneys to help represent these corrupt elected officials and their nonsense and buffoonery. You know, you're already getting some work here. It's not like you can't find a client. But it doesn't matter if you're being sanctioned in order to pay attorney and court fees to the opposing party because your dumbass client is dictating how you should practice law. And now you're getting caught up in that nonsense. And you're being severely reprimanded and or sanctioned. So what difference does it make if you take on a high profile case but you lose more than what you earn? You're going to lose more than what you earn, because now you're having to pay all that money back out in attorney's fees. And I hope the guard is hefty. Please let it be something around at least $10,000. God almighty. You got to pay all that money back out that you thought you earned.
I understand penalties are strictly construed. And even your actions are strictly construed, so as to not penalize you for making honest efforts. But there's no honest effort I see here.
None.
Could have countenanced any allegation that they were
that it was illegal
or encouraging a division among the trustees when they only opened up their doors, which they had a right to do on behalf of any one group or all parties.
Yep.
That was their decision.
Yep.
And the law gives them that right.
Yep.
I can understand, honestly, why the mayor took umbrage to that and why she felt they were taking sides. I can understand that. But that understanding that doesn't countenance filing a lawsuit where there is none.
Right. It doesn't mean
there was none here.
It doesn't mean that it was illegal. In her words, illegal, lego my ego. It does not, you dumb goon. It does not mean that everything's illegal because you don't like it. It obviously, and that's exactly what the judge is saying. Obviously, he's going to say he understands your point and your position, but he's not going to agree with it when you're saying that it's illegal for them to exercise their right to assemble and have a meeting as elected officials on behalf of any party or any group, whatever. So, no, you don't get to come to court and say this was illegal. What law was violated? Even Max Solomon had to say it was legal. Okay, so why you filed this stupid ass lawsuit, bro? Come on, man.
Ordered by me.
You agree that it was no violation of law, so why are we here? Get the hell out of here.
Arguing that they encouraged division in the body politic of the
festering division. Ugh.
Festered it.
Festered
Like
it.
somehow they're spreading a disease.
Disease? Exactly. God.
Unbelievable.
Unbelievable. Thank you.
And wrong.
Absolutely wrong. All the way
Not
wrong.
borne out by existing law.
Not at all.
You're entitled to your opinion about what the facts show. But you got to have law.
Law to support it. Thank you.
You didn't have law in inception to support it. And you didn't have any law in terms of the process by which you used to file count 3.
Mm-hmm.
I do understand that you've since filed an amended complaint. We're not talking about that.
It doesn't matter because he dismissed it either way. So you can amend it 1,000 times. There's no finding of fact or law on the simple basis of Dalton trustees having a meeting in Dalton Park District. None. There's nothing illegal about that act. It's constitutionally protected activity. And It does not violate state statutes or municipal codes. So whether it's the federal, state, or local level, it didn't violate any law at all in any of those levels. Not even a little bit. And you're allowing your dumb client to tell you something's illegal. Why are you allowing her to tell you that, Max Solomon? You know the law. Why are you allowing an idiot to tell you, who did not go to law school, that something's illegal? Who the hell told her that? Michael Smith, please stop talking. You goon. You did not go to law school. You don't know how government works. You don't know how the law works either. Whoever keeps advising her and telling her that was illegal. These idiots did not go to law school, nor do they have to represent her in court, because then they didn't go to law school. You're not attorneys. You wouldn't be able to represent if you wanted to, because you're not attorneys. The court and the law does not allow you to represent someone else when you're not a bar licensed attorney. So shut the fuck up. And Max Solomon, you need to grow a spine and a sack. Grow a sack, bro.
In order to combat this,
Being a simp.
district had to
He's a complete simp.
legal fees and costs.
Yep.
I don't know what damage the Park District is.
All of it. All the damage. Emotional, mental, financial.
Lack of faith in it. I haven't been asked to give damages as to that, and I wouldn't.
Right. Because he can't.
They're ambiguous and vague.
Yeah, it would be, when he says this, he means damages like, let's consider a class action lawsuit, if you will. Class action lawsuit, they're asking for attorney's fees, court costs, and damages. And what does that damage look like? Sometimes the damage can be measured based on, let's say, if it's someone hacked into a system and got people's, social security numbers and date of birth. Well, damages could be, I want my money back for having to get LifeLock, and here's how much I had to pay for that. Or my information got hacked and someone bought a whole house in my name for $250,000. I want all my money back for that, and money to have to pay for LifeLock, and money to get my credit repaired, and money to get my stuff secured and locked down again. Or I had to get a whole new driver's license. I had to, stop using my address and use a P.O. box because all my information got hacked from this one company because they could not figure out how to put up a firewall. That's how you calculate damages. When it comes to mental and emotional damage, okay, are we talking about you having to go out and get maybe some therapy for this? Did it cause you to be so distraught to where you miss work? Did you have to go to the doctor? What was that toll that it took on you mentally and emotionally? And then you kind of give a roundabout figure with this. But because damages aren't being requested as a part of the relief, meaning the attorney for Dalton Park District, the Dalton trustees, they're not saying 20 people came out and they drove X number of miles, had gas in their car, and because she filed this lawsuit, these people had to go out and hire attorneys because, they've been named in it and they have to now have somebody to represent them. That's the type of damages that can be calculated. That would be reasonable. Damages you incurred from this lawsuit. But damages haven't been requested, and it would be, how would you verify and calculate and come up with a number to grant all of the defendants or the victims that are entitled to damages in this type of situation? That's what he means. So for this type of complaint, how can you calculate what damages would look like for the residents that had to come out to Dalton Park District for a meeting because they couldn't go to town hall because Super Stupid locked the damn door and refused to open it. So if someone wanted to, they could file a complaint to say, I had to drive to Dalton Park District, and because I was there, I parked in a space, but my car got towed, and it was not supposed to be towed. Now I had to pay $500 for the ticket and the tow and all of that. That's damages. Because had that meeting been at the town hall where it should have been, this would not have happened. And then this heifer wants to file a lawsuit when I had to get my car ticketed and towed because I drove to a meeting at Dalton Park District when it should have been at the town hall. Something like that is calculable and measurable. But when damages is not even being requested and no one is saying what type of expenses you incurred because that meeting was at the Dalton Park District, it's kind of hard to calculate and figure out what damages would look like on behalf of the citizens and the taxpaying voters of the residents of the village of Dalton. So if you had something to happen, though, you might want to contact the attorney and ask questions and say, I got a $25 parking ticket. How is that not damage? I wouldn't have gotten that ticket, though, if I would have been able to go to the town hall where we were all, legally authorized to have a meeting at or attend a meeting and participate in what the hell is going on with our local government. I wouldn't have incurred that if it were at the town hall because I never got a ticket at the town hall. I parked at this place. I took a picture. They came and they just ticketed. Ticket was invalid. Had to pay the ticket. Had to go to court for that. Here are the damages from that. That's one thing. So if you had something like that happen, you might want to talk to the attorney about it. But he's simply saying it hasn't been requested. I wouldn't grant it because there's no way to really calculate and verify any of that. And, it wouldn't be hard if you have evidence to show that I incurred this ticket because I went to Dalton Park District for a meeting to participate in a constitutionally protected activity. And as a result of that, I had to spend X amount of dollars for this ticket or to get my car out of tow or whatever. And that's something you could present to the court with statements, receipts, documentation to support that. And then the court probably could grant that. This would be, Your Honor, this would be a rare situation. This has never happened any other time. I have a parking spot at the town hall. I don't have to worry about that there. But I had to worry about that at Dalton Park District. Look what happened. Now I got a ticket. Something like that. I mean, and I'm just giving to be honest, it's a very extreme example that I'm giving, but that just kind of helps. Hopefully that adds some level of insight in what he's saying and why he's saying I would not grant damages because there's no way to know damages were incurred from this, seeing that it was not requested, don't have any evidence or exhibits on that. How would you really calculate that in the first place? What would that look like? There's a lot of ifs in that. And I can't say, with a blessed assurance that I would just grant damages. It would have to be taken on a case-by-case basis. It really would be. So, moving on.
Incapable of really being known. But the law says that not only is the Park District entitled to their legal costs for fighting this initial complaint, and for fighting against an injunction, they're entitled to fees on fees for arguing the Rule 137 motion.
Yep.
Meaning today and in the future.
Yep.
As I said before, I think the Park District should have supplemented their motion or filed their original motion by attaching to it its fees so you could see them. I will require the Park District, I will bifurcate this hearing to require the Park District to file exhibits of legal fees.
He's bifurcating the hearing, separating that part out of this hearing because he's going to give them the opportunity to submit their exhibits for those fees. He's going to grant the attorney's fees and court costs and whatever else. But he's going to handle that one separate issue in another hearing. But this is what she was saying. Who knows how many more hearings we would have on this matter, and I'm not going to just submit something concrete, and then he has this false perception that this all she asked for, this is all I'm paying. But yet, there are other hearings where more fees and costs will be incurred. So notice the judge said for today and moving forward, meaning any fees that the opposing counsel requests, for having to defend their client in this case or in this particular matter, I am going to grant those fees to them, the attorney fees and the court cost fees. I'm going to grant it. So if there's 6 more hearings, he's going to grant whatever costs associated with that, with having to defend it or to represent their client in this, in the next 6 hearings. So they might want to cut the shit and stop prolonging this nonsense and buffoonery, because the opposing counsel is going to get all attorneys' fees and costs incurred granted to them, whatever that looks like. And Lord, we thank you.
Counsel, I have a question for you, counsel. Are you hired by do you work as a salaried employee?
Please ask Mike Solomon that. No, she's an outside attorney.
That makes a big difference. They're entitled to the lawyer of their choice. If it was someone internal, I can't say who was on salary. I wouldn't attribute any legal expenses. But they're entitled to hire you if that's what they wanted to do.
Yep.
And you have succeeded. You're entitled to your legal fees for the work you did in this matter, including the work you have performed to get the legal fees returned to the Park District that they're going to be paying you and costs. But you must attach them in an amended motion or amended exhibits and give them to file them. Yep. Give them to Mr. Solomon. Give them to me.
Yep.
The next.
And that's. I mean, honestly, the attorney for the Park District, she was like, I accept that. I should have done that, and I accepted. Here's why I didn't. And it was up to the judge to accept that logical reason and a reasonable explanation. It was logical and reasonable. But now that he has secured and guaranteed her the reimbursement, moving forward in the future, any and all, attorney's fees and costs associated with this dumbass frivolous lawsuit, now she can attach those fees with her motions or pleadings that she files in this case. She doesn't have to ask, okay, how is this going to go, case by case or hearing by hearing. So now that she's already been guaranteed, you're going to get your money back. Just make sure you continue to attach those fees and costs with your original file stamped pleadings to the court. That she accepted that all day. She didn't beat around the bush. She didn't sit here and try to dodge the question. She just gave a reasonable explanation as to why it wasn't initially done. But now she's like, oh, we're going to be doing that moving forward now. Okay, cool. See that? Very easy and simple. He asked Max Solomon the same question 16 ways, and he still couldn't say yes or no until he was pretty much cornered in and didn't have a choice. Good grief.
Date is a date on which I will listen to what Mr. Solomon has to say about that. I will also on
Judge
that
won't
date
care. He's going to grant
consider, since no one has dealt with it, whether I should attach these costs and fees to Mr. Holmes, Mayor Henyard, Mr. Solomon, as a group, individually, together, or severable. I would like
individual.
I know what the law says, but I would like to hear what the parties have to say.
Individual.
Are we clear, Mr. Solomon? Anything you would like to say? Anything you'd like to say, counsel?
He can. I guarantee you all, he shook his head and said no. Because what can you say to that? What I wish the judge would have asked is, Mr. Solomon, who is paying your attorney's fees? And what role or capacity are you representing Super Stupid here? I mean, is it in her personal or official capacity? Because if it's in her official capacity, were you approved by the board to represent her in all this nonsense? And if it's in her personal capacity, then she better be paying you out of her money and her income and not with tax dollars. I wish to God that judge would have asked that. Would it have been improper? It would have been a good. It's just a question we all need to know.
When are we coming back on all these cases? Let me take a look at my notes. Your depositions occur on 3/5.
March 5th.
Sometime thereafter, we're going to have our expedited hearing that you request. We haven't figured out when that's going to be. I should give another date for status just to determine when that hearing is going to be. It should be sometime after March 5th. So let's put this over for further review of this Rule 137 matter, as well as when we're going to hold an expedited hearing, but not the hearing.
Because they asked for an expedited hearing. Why? I don't know. But if the judge dismissed the complaint about it being illegal, then what do you have left? I mean, what is the expedited hearing going to be about? If Max Solomon was smart, he would withdraw the matter altogether and then tell Super Stupid to kick rocks and jump off a bridge. Because you're going to get utterly destroyed. Now, I'm here for that all day. You're just giving us more material to report on YouTube. But if he was smart, he would say, I'm going to just retract that whole thing because, yeah, he's going to have to pay more court costs and attorney's fees. So my question is that money that he's receiving coming from taxpayers or where? Where is that coming from? Because that should not be coming out of taxpayers' funds. Max Solomon should be getting paid out of Super Stupid's personal income. And I would challenge the court to please garnish her wages. Whatever source of income she gets, garnish that crap and take the attorney's fees and court costs out of that you're going to be giving over to the Park District and to the attorney representative. Garnish her wages for it. Do an IDO. Because at the end of the day, you got to question how is that, even if you grant the judgment, you're going to have to question, how is this going to get paid again? Because it better not be with tax dollars. You don't get to put this financial burden on the taxpayers any more than you already have because you want to drag these people to court because you want to throw a tantrum. Hell no. Garnish her wages. Do an IDO.
In itself. How is March 13th, everybody?
Fine.
I didn't hear you. We do? What's on February 13th? Well, let me take a look at it. I'll look at my file. Thank you for letting me know.
He getting in their ass, and I love it. We are here for it. Yeah, this is the boring parts about court that people often underestimate.
One other thing.
Don't shout without me, Jedediah, a.k.a. Bishop.
Which maybe is the most important thing.
Talk
and
about
it goes both ways, by the way.
Because he wants to be fair and neutral.
It's right at the top of my notes. I can understand, as I said before, why Mayor Henyard took umbrage at the Park District doing this. But they had every right to do so.
Yep.
I'm more concerned with the general idea here of suing the Park District when existing law said they could do what they did.
Come on now. Speak about it.
It serves a chilling effect.
Yes.
on the marketplace of ideas in the village of Dalton.
Come on.
Everyone should be heard. Everyone should have an opportunity to be heard. I told you all before, I'm going to call these cases just as it is. I don't have a horse in this race.
Nope.
But everybody should have an opportunity to be heard.
Yes,
And
Lord.
when you sue somebody,
Come
because
on.
they just provided a place for the marketplace of ideas to be exchanged,
Uh-huh.
even though not all the people were there.
Uh-huh.
An issue that we're going to discuss later. When you sue the person who provided the hall,
Uh-huh.
that this marketplace of ideas could be held, it serves a chilling effect
Yes, sir.
on the operation of government and, yes, the First Amendment.
Yes. Yes.
And I'm concerned.
Can we hold on? How many times has Super Stupid infringed upon the First Amendment right to freedom of speech and expression in many town hall meetings? To the council representing the Dalton Park District, please pull all the videos where she tried to kick people out, prevent people from coming into the town hall, or shut people down from freely speaking and exchanging those ideas. I did how many videos last year where I talked about that alone? Who gives her the damn right to infringe upon someone else's constitutionally protected activity of the First Amendment? The right to have the freedom of speech and expression, to air your grievance against your government, the elected officials that's supposed to represent you. You have the right to tell them when they're effing up. You have the right to say, you suck, and you will be voted out. Kick rocks. Goodbye. Mic drop. Enough said. Our votes do the speaking for itself. You get that salary you get because of votes. And I told you all, Super Stupid is going to get to the point of desperation where everything she says and does, you better take it as a threat. I wouldn't let nothing get past if it comes out of her damn mouth. She has some loyal goons that are willing to do some very dangerous shit to try to maintain and hold on to power and to file these frivolous lawsuits where you're basically trying to shut people down from exercising their First Amendment rights. I don't care which amendment. Pick one. Their constitutional rights. The right to assemble. Freedom of speech and expression. The right to air your grievance against your government, your elected officials. The right to protest. When she is doing this to infringe upon people's constitutional rights, that's when the courts need to step in and say, you will not do that. And if you keep doing it, you're going to catch a federal lawsuit for that. Because you're talking about federal laws being violated when you infringe upon others' rights. That is guaranteed to them under the United States Constitution. You don't like our U.S. Constitution, Super Stupid. You and your criminalistic boyfriend can get y'all black asses out of here and leave this country. No one is forcing you to stay here and abide by our rules and laws. But if you're going to be here, our Constitution reigns supreme here and it's the law of the land. You don't have to like it. But you do not get to infringe upon anyone else's rights either. Because you want to throw a tantrum and be a dictator. You brainless goon. You don't get to do that without penalty. Here is the consequence you're going to have to bear. Preferably, it will come in the form of a separate whole payment you're going to have to pay to an attorney. I say if you sanction the attorney, get the other two as well, Judge. He who will not be named is Super Stupid. Sanction their asses as well. With a hefty fine and fee. Make it hurt. I want them to walk out of there saying, I'm going home and going straight to bed. Making it where she can't do nothing else but take her black ass home in that overpriced $150,000 Tahoe that I know she got a kickback or two on. Because don't nobody spend that type of money for a Chevy Tahoe truck. And go home and go to bed. Because she can't think about nothing else. Let that happen. Got a stylist and all this stuff. And then she still got all these old frivolous expenses that somehow are being paid through some means. I don't understand it. When these credit cards and the bank's accounts that she's on gonna get cut off. Cut all of them off. Are you kidding me? How was she paying Max Solomon again? Yeah, okay. I'm so glad he said that. You don't get to infringe upon anyone else's constitutional rights. Freedom of speech and expression is that one right we do get to enjoy here in the U.S. And if you want to be a little dictator, take your ass to North Korea. Good luck to that. I see how they go.
About that.
Go over there to North Korea with that
I'm
crap.
concerned about anyone in government, whether it be a
If
part.
North Korea is looking to buy a human, Tiffany Henyard is for sale. Listen, we'll give you a discount and a promo code. Matter of fact, I'm willing to hand her ass over to North Korea for free. You can have her for free.
District.
Hell out of here. Hell out of here.
Or on the other side,
Yep.
acting in a way to prevent the other side from being heard. Consider that a comment on all of you not holding meetings because you don't want to give an opportunity for the other side to be heard and to act, even when you're in the minority.
Yep.
Citizens of Dalton have a right to be.
Super Stupid is definitely in the minority.
In effect and working. And it's not being done. If you sue someone because all they did was open up a hall
and have a meeting,
government to operate as they had the right to do.
Yep.
It may be that everything that was passed at that meeting is void. Something we'll talk about. But that's not what I'm talking about. Suing someone because they operated according to statute and made a decision that was they thought appropriate is not okay. It violates existing law, and it serves to chill people's representatives, representative government from acting.
Yep.
I wanted to make that clear. Let me take a look.
Loud and clear. Loud and clear, Judge. We heard it loud and clear.
Henyard versus Key.
And you guys can tell he's saying this for both sides, really. He's saying, listen, the trustees don't want to hear her goons talk, so we're not going to come to a meeting. I don't think that the trustees, and I'm saying this in my personal opinion, they're not stopping the meeting from being conducted because they're not showing up. She's just trying to give this false perception that nothing is getting done because they're not showing up. When in actuality, Super Stupid, you are uninsurable. The insurance company is not under any obligation to cover your black ass because you keep catching all these lawsuits and now you're going to be paying some attorney's fees and court costs. Keep going to court over this dumb crap if you want to. You still going to have to pay the opposing counsel's attorney's fees and the court costs. Oh, yes, you will. He's already said he's going to grant that. Past and future and current fees. He said moving forward. All the fees you incur now moving forward. Just attach your exhibit. His question lingering in his mind is whether he's going to make you pay it individually along with Solomon and he who will not be named and make y'all pay an amount individually, or grant a judgment where you three pay it collectively, and however you all come up with that money, you get it paid collectively. More than likely, if it's let's say it's 30 grand, you probably still had them all paid 10,000 equally. But it'll be this one collective payment as opposed to Solomon gets 10-15,000, Super Stupid get 10-15,000. He who will not be named gets 15-20,000 because he's a nasty piece of crap no one likes. But however that breaks down, he can do it individually where he can have them paying different amounts. As long as it equates to whatever that total amount is that he grants to the opposing counsel. So if she submits over expenses that equal up to $30,000, he could, like, okay, you pay 10, you pay 15, and you pay 5, or something to that extent. Or you all three are going to pay that $30,000, and you'll just split it equally, 1/3, 1/3, 1/3. So it could, that's what he's going to figure out. But there's no question that the opposing counsel will get her attorney's fees and court costs. She's going to get it. It's just depending on how it's going to come. I personally would ask for an audio or some sort of garnishment when it comes to Super Stupid, because she's got so many other judgments for lawsuits she's lost that she has to pay. The girl barely pays her rent on time. I wouldn't trust her to pay that on her own demise or her own accord. Now, Judge, she has a history of not paying bills. Please take it out of her check. Please garnish it, because I won't get my money if I have to wait for her to pay me a judgment. She's not going to pay it. Then we have to come back to court, and the attorney will have to file a motion to compel her or to force her to pay it. And then she still might not do it then. You might have to take the threat of jail time for her to do it. All right, go to jail until you pay these attorney fees. Because they could get an order from the court ordering her to pay the fee within a certain time frame. And if she don't, a capious warrant will be issued for your arrest. Or you can just go to jail now and just report. Or we'll come pick your ass up. How you want this? You either going to pay it, we pick you up and collect you, or you turn yourself in. And she could be capious. And sentenced to what the maximum in that matter would be, 93 days in jail? In the county jail? But she would go to jail if she didn't pay those attorney fees. The attorney gets an order compelling and mandating her to do it. See, that's where a mandamus comes into play. A mandamus. That's where that comes in. That's where you get an order of mandamus forcing her to pay attorney's fees. That's something that will be applicable. Come on now. I'm loving this judge.
That's what I have.
I love it.
Put over till today's date.
He's like, I'm not playing with y'all.
Or goes there another? Or what was the date? That's what I got. November 20th order. Oh, you have the court clerk on its own.
I didn't see it up there.
You have a February 23rd. Would you please strike that date, Mr. McGrath? The clerk gave us a ICM date of 4/13. Thank you. So that's stricken.
So you struck that date.
It's February the 13th. 13th. Strike.
All right. So when do you want to come back after the March 5th deposition to discuss further proceedings?
Y'all know a deposition is like a Q&A.
Mr. Sullivan.
He want a deposition. Woo, child. Please depose Super Stupid.
On an expedited hearing on the complaint.
He needs to withdraw it.
The Rule 137 final order.
Yeah, that's going to be a final order.
March 8, 9, 10.
Mr. McGrath, Park District.
March 10th.
That's fine. Just to make sure it's soon after the
March 10th, I am available. March 10th.
Mr. McGrath? If no one has to be here, it'll be by Zoom.
Right. Because you're just talking about the exhibits for the court calls.
Is there something else, another day you'd like, Ms.?
In the deposition.
Yeah, the next week is the national holiday of St. Patrick's Day, so we're not going to use that day. But how is the 18th, 19th, 20th?
Come on, pick a day.
This is not for a trial. This is just for to continue the 137 hearing and to set it for trial.
Right. 30 minutes.
So the 28th would be better, but I can make.
All right, 20, Mr. McGrath.
that work session on this first order. We have on March 13th.
1 second before we get to it.
Oh, that gets fine.
Come on, y'all. Pick a day.
I don't have you coming back for me on any date. Do I?
And there you have it, ladies and gentlemen. Judge.
So that's what happened. He basically, they gave a date aside from the March 5th date. There's a deposition that's scheduled, and then he's trying to schedule just a continuation of that Rule 137 hearing regarding the attorney's fees and the court costs. He's already said he's going to order them to pay. He's just going to determine how that's going to be paid to the opposing counsel representing the Park District, as well as set the date for that expedited hearing that they wanted. If Max Solomon was smart, he would withdraw that motion for an expedited hearing. If he was smart. But he thinks he's proven a point of trying to get his name out there when all he's doing is making a mockery of the court and making himself look like an incompetent jackass that doesn't have a spine or a sack. So this is where we are now. We gotta wait for that hearing. To me, is going to be a lot more interesting, and it should be brief. It should just be a matter of, here's the exhibits for the fees. What's your thoughts on it? Blah, blah, blah. More than likely, unless he wants to be questioned how the hell he gets paid and where that money coming from, he's going to more than likely just, not give too much back and forth and riff on it, because it doesn't mean anything. He's still going to be ordered to pay something. And then they're going to ask, I guess they're going to be asked what they think about being ordered to pay it collectively or individually. Each party for the defendant in this motion or petition in the matter, that being Max Solomon, Super Stupid, and he who will not be named, whether they're going to pay this individually or one big total collectively, and probably just be told to still split it 3 ways. Because you tell them to pay $30,000, it's not going to all come from Max Solomon when he orders them to pay it collectively. And that's if the judge decides to include the other 2 in it. But he definitely is going to make that attorney, boy, he got it coming. So I hope that they have to pay something individually, be ordered and mandated to do it, and Super Stupid gets it garnished out of her wages. Because that's the only way it's going to be guaranteed to be paid. Or she's under the threat of going to jail. That means that you go in there and play with that judge if you want to and think you're going to violate that order. Good luck to that. You're as dumb as you look now if you think that you'll be able to violate that damn order. And don't make that attorney have to take you back to court to get a mandamus or get an order to compel you to pay it out. The only thing that judge is going to say is, I'm ordering you to pay it by this date. And if not, a capious warrant will be issued for your arrest. Issuing a bench warrant order. You'll be going to jail. Pick one. That's what it's going to come down to. So this is, and then they have this expedited. So there's 2 more hearings coming up with this. And the opposing counsel is going to get her attorney's fees and court costs with the next 2 upcoming hearings. That's why I keep saying if Max Solomon was smart, he would just let that motion on the Rule 137, let that finish out. And don't give the judge a hard time about this attorney's fees and all that, because he don't want to say how he can get paid. And dismiss withdraw the petition for the expedited hearing on everything else, and let this go and go home. And then if Super Stupid wants to go and pursue something, you tell her flat out, okay, you can go get another attorney, or you doing it pro se, but I don't want to have anything else to do with it. I already got to pay all these attorney's fees, and I got a headache, so I'm done. That's it. That's how they can go. But this is 2 hours and 14 minutes long, so more than likely, I'm going to be splitting this video up, because it's going to take 1,000 years to upload this video. So I might split it up. It's definitely going to be put under the Lady Luck Club podcast playlist as well. You can listen to it while you're driving, sitting in traffic, at work, cooking. However, have a good laugh. And man, this was exactly what all the other court hearings should be like. You should have a fair, impartial, objective judge that if he gives his opinion, his insight is still founded upon law. He cited several case law, about 7 or 8 good ones that they can easily go back. Anybody can go back and write down and look up and research and read for yourselves. He even said, I implore you both, all of you, to read some of these case law and opinions and op-eds written by these judges in this case law I'm citing here. And it helps to establish that precedence. So that's exactly what you want. You don't want a judge that's gonna go in there and sound like they on one side or the other too far. I want Super Stupid to lose all her dumb, frivolous lawsuits. All of them. Because they're not founded on the law. But I do want a judge that's going to be fair. If he's going to say, hey, y'all got to be able to let other parties come in and speak and exercise their First Amendment rights. I'm all for that. Now, a couple trustees not showing up to a meeting, here's why I would disagree. That doesn't stop the meeting from occurring and people being heard, because there is a meeting that occurred in Thornton Township last week where Keith McFathead, McChicken Nugget, got up and spoke, told somebody that they were beneath him, as if, you're a big guy. That's not hard for somebody to be beneath you. I would pity the day somebody ends up beneath you. All that weight, that cow meat pushing through your blood veins. Shut up, boy. You oozing Big Mac sauce. Get out of here. He smells like a biggie size fry. Bye. Bye, Felicia. Talking about somebody beneath you. I hope not. Dear Lord, let me know if you end up stepping on somebody, because they need to be rushed to the hospital. I can keep going. Anyway, they had a meeting where Gonzalez and Carmen Carlisle, they was like, we out. But they didn't stop the meeting from happening, Judge. That meeting still occurred, and her goons got up, said what they wanted to say. But she keeps lying about some insurance that can easily be renewed when her name comes off that policy. Insurance companies are private organizations. They're not indebted to cover you. You're uninsurable and you're a risk because of these lawsuits. This is Exhibit A as to why an insurance company is tired of trying to cover you. Because you're about to be ordered to pay some court costs and attorney's fees. And you are not going to want to pay that out of your pocket. And I'm sure your crooked ass would want to file a claim to get some insurance company to pay it. And they're finally saying, hell no. So you get your name off of that policy for the good of the city you claim to love and the people you claim to love, and let the insurance policy be renewed without you on it. And then you go get your own insurance and pay for it out your pocket and keep living and kick rocks. You're going to be voted out anyway. But then the 2 trustees leaving did not stop the meeting from occurring. And no, they're not under any obligation to listen to all this nonsense coming out of her goon's mouth, because we barely want to, but we report on it because we're going to keep doing it. Yep. Yes, we are. But those 2 trustees, there are local municipal codes that, pretty much empower them with the ability to determine if they want to have a special hearing or meeting or quorum or whatever or not. And if they don't, they have it by a majority vote. So that's the power that they hold. They don't have to sit down and listen to some nonsense. and listen to her say the same old thing over and over again where she lies like hell and wants people to bend to her will. That's not how this is going to go. It's not going the way you want it to go. Go throw your dumb tantrum somewhere else. If North Korea wants her, we are ready to ship her off to you. All right. I hope y'all enjoyed this. This was so good. Thank you, Bishop, for playing this out. This was a 4-hour live stream, y'all. But please check this out. Make sure you guys support Bishop. Like his videos, subscribe, and then come over to the Lady Luck Club and like and share and subscribe. I'm trying to get to 50,000 subscribers. I want to get to 50K. There's a lot of content, a lot of information I'm going to be pushing out, and vital information, entertaining commentary people need to know and will enjoy. I promise you all it will be worth that sub. And hit the like button. Let's keep these videos in rotation. Let's keep them at the top of the list. And you guys, feel free to comment. Tell me your thoughts, what you think. I expect people to agree or disagree. However, I have no horse in this either. But you don't need to be born there to know that Super Stupid is crooked as hell and she got to go. So, y'all continue to be safe. Take care of yourselves. There's more content coming. And until the next one, Lady Look out. Peace.